Hello friends, today let's have a discussion on void. An agreement which is not enforceable by law is said to be void. A void agreement doesn't create any legal rights and obligations. Different types of void agreements are the agreements by incompetent parties, agreements made under a mutual mistake of fact, agreements with unlawful objects and consideration, agreements made without consideration, agreements in restraint of marriage, agreements in restraint of trade, agreements in restraint of legal proceedings, agreements the meaning of which is uncertain, agreements by way of waiver, agreements contingent on impossible events, agreements to do impossible acts, reciprocal promises to do certain things which are legal and certain others which are illegal. Then first one is agreement in restraint of marriage. All agreements in restraint of marriage, they are void except those of minors. In that case, it is valid. A major person has a freedom of choice in marriage, and the law considers marriage and marriage status as the right of every individual. That's why it is said to be void. Then agreements in restraint of trade. Every person has freedom to legally practice any trade, commerce, or profession. So, an agreement in restraint of trade, it restrains a person following a profession of his choice in a lawful manner. That's why such an agreement is void. But there are some exceptions under Indian Contract Act, Partnership Act, and exceptions under judicial decisions. Okay, then agreements in restraint of legal proceedings. Every person has a right to go to court to enforce their legal rights. We know we have legal rights and obligations. So we have the right to go to court or to approach the court to enforce our legal rights. So an agreement that restrains the justice, it is void as it is opposed to public policy. Then agreements of uncertain meaning. Agreements made in such a way that the terms used therein are uncertain, they are vague and they are not clear. In such a case, the agreements are void. They have no legal effect. Then wagering agreements. These are agreements made by two parties in which one party agrees to pay a certain sum of money to the other party if something happens or doesn't happen. Such agreements are void. Say for example, Mr. A agreed to Mr. B to pay rupees 100 if it rainy on tomorrow. Okay, and if it is not rainy one, then B has to pay rupees 100 to A. Such kind of agreements are wagering agreements. They are then essential elements of a wagering agreement. When we call an agreement as a wagering one, there must be two parties, both of whom stand to win or lose equally. They should promise to pay each other money or money's worth. Their promise should be based on the happening or non-happening of something. The promise should be based on an event that is uncertain. What one party gains should be the loss of the other. Both parties should have no interest in the event other than the money or money's worth they are going to win or lose. Then, one thing we have to remember is that lottery is a wagering transaction. At the same time, a crossword competition, it is not a wager because it requires a lot of skills to solve it. Then, is there any kind of relation between insurance and wagering agreements? In an insurance contract, the insurance company, in consideration of certain money, undertakes to make good the loss suffered by the other party on account of an uncertain specified event like death, fire, accident, etc. So, contract of insurance, it's not vaguer because the insured person has insurable interest in the subject matter. But in a wagering contract, the case is not like that. No one has any interest. In insurance, both parties are interested in protecting the subject matter. And in an insurance contract, except in life insurance, there is an indemnity. But in case of wagering, the amount is fixed, no chance for having an indemnity. Then, insurance contracts are beneficial to society, while wagering contracts do not provide any services to the public or society. Insurance contracts are made on the basis of scientific and actuarial calculation of risk involved. But in a wagering agreement, it is a mere gamble and nothing more. Insurance contract is valid and can be enforced in a court of law, but wagering contract is void and has no legal effects. It cannot be enforced. Then contingent contract. It's a contract to do or not to do something if some event collateral to such a contract does or does not happens. In an absolute contract, the promisor undertakes to perform the contract in all events and without any condition. But in a contingent contract, it depends on something else happening or non happening, which is collateral contract. Then, characteristics of a contingent contract. It's a conditional nature. It depends on the happening or non happening of some future uncertain event collateral to the contract, and it will be valid only when there is a valid contract between two parties to do or not to do something. Performance of the contract is conditional, and the